Since it's 5 o'clock, I'd like to call the November 21st, 2019 Houston County Board of Adjustment meeting to order. First, we'll approve the agenda, which is pretty short. Does any of the members have a correction to the agenda?
Motion to approve.
Second.
We have a motion and second to approve the agenda as presented. All in favor say aye.
Aye.
Next, we'll go over the minutes, get that out of the way, get some housekeeping done here. Has everybody had a chance to review the minutes?
I'll make the motion to approve the minutes.
We have a second.
Second.
We have a motion and a second to approve the minutes as presented. All in favor say aye.
Aye.
The next thing on the agenda is the zoning appeal hearing, Cruco Companies LLC, Winnebago Township. Appeal is zoning administrator's decision of February 8th, 2018. I would just like to go over what I anticipate how this is going to work. We'll do the roll call. I'll do read the public notice. Then the county will present their information. We would try to keep it to 30 minutes. We should have question and discussion from the Board of Adjustment members. Cruco will present their information, and we try to keep it to 30 minutes. Again, then we'll have questions and discussions by the Board of Adjustment members. Then we're opening it up to the public. If anybody has any comments or additional information they would like to share there, we would like to keep that to 2 minutes. We have the meeting guidelines. We don't have a large crowd, so maybe we don't need to go through them. Then the county representative presents any additional information or reply to any of the information or questions to that point. Again, we have questions and discussions by the Board of Adjustment. Cruco representative presents any additional information or reply to any of the questions at that point. And then we will close the public portion of the hearing. We'll have questions and discussions by the Board of Adjustment members. Have finding of facts. And since with the Board of Adjustment, we normally have findings that are defined in the zoning book, which we won't have that, so the Board of Adjustment is going to have to identify the critical issues supporting their final decision, and then we'll vote on that, on each of them with a roll call vote. Entertain a motion to accept or reject the findings, and then we will have entertain a motion to accept or reject the Cruco Company's request for appeal to overturn the decision by the zoning administrator in this matter. Entertain a motion to direct the zoning administrator to prepare findings in accordance with the Board of Adjustment decision and adjournment. So, unless anybody has any comment on that, we will start with the county representative presenting their information.
Good evening, members of the board.
We inserted one here
Okay.
that I didn't go through. Who is going to be representing the township?
County.
Yeah, who's going to be representing the township?
You mean the county?
I'm sorry, yeah. I see, yes, who's going to be representing the county?
Yeah, well, Mr. Chair, Jay Squires, Rupp Anderson Squires, Weltsberger. I've been working with Aaron, and I have some introductory comments, and then we'll turn it over to Aaron to present the bases for his decision that's been appealed, and then I likely will come back to visit with you during that brief reply period to discuss the matter further as well.
Thank you. And who's going to be representing Cruco?
My name is Renelle Lear. I'm an attorney at Fox Rothschild.
Okay, one other thing we gotta get take care of here. Is any party challenging the Board of Adjustment members to identify the following? Will the Board of Adjustment be challenged as to be have conflicts of interest with this meeting? Do we have any? We had some the last time. We got a procedure we go through here. We've got the
Not from county staff, no.
how about from Kruko? All right, thanks a lot. Get that out of the way. Appreciate that. All right, read the public hearing notice. Kruko Companies LLC, 506 South Highway 44, Caledonia. We don't know the address. Is seeking zoning appeal in regard to a zoning decision affecting land that is owned by Gary Miners, 15497 Miners Road, operated by Bonanza Grain Incorporated / Kruko Products, 506 South Highway, Caledonia, in Section 5 of Winnebago Township. The matter was previously considered and denied by the Board of Adjustment meeting of June 21st, 2018. It was appealed to the District Court January 2019 and was subsequently remanded back to the Board of Adjustment for redetermination. With that, we will listen to the presentation by the county representative.
Thank you, Mr. Chair. Members of the board, I want to first take just a couple minutes to discuss some of the procedure to put this matter in context and frame the issue for you. I think your public notice just did a little bit of that. And then I'd also like to spend a couple more minutes on the concept of what nonconformities are and what the rules of law, both at a state level and under your county ordinance, are, because they have a bearing on the decision that's before you again for the second time. I did represent the county in the district court action that involved the first appeal, so I have that experience as well. Essentially what this is a redo. Back in in June of 2018, you made a decision on the same issue that's before you tonight. It went up to the district court. It was appealed by the Krukos. It was sent back by the district court without the court offering any determination on the merits of the case. The court determined that board member Van Gorp, for the court's own reason, shouldn't participate in this rehearing, so the district court basically sent it back and said do it over. So that's why we're here today. So the issue before you tonight is the same issue that was before the Board of Adjustment in June 2018. Whether County Zoning Administrator Locker erred in concluding that the evidence that he gathered supported his determination that the Schutz Quarry property did not have continuing non-conforming rights due to long periods of disuse. So that was the issue back then, and that's the same issue for you tonight. Now with that background, I just want to spend a couple minutes, as I mentioned, on the concept of nonconformity, and because that's important in the context of your decision tonight. A nonconformity is a use that at one time met pertinent rules and laws, but no longer meets the rules and laws. A county can't change the rules and tell people to stop doing what they've been doing. They have sometimes called grandfathered or grandparented rights to be able to continue what they're doing even though you've changed the rules. So that's what a nonconformity is in concept. It's allowed to exist under both state law and your county ordinance. In the context of this case, the mines were allowed to exist without any particular special type of permit until the county zoning ordinance in 1968 required a conditional use permit. So all those mines that existed, even though they didn't have a conditional use permit, were allowed to continue as nonconformities. Now, does that mean under state law that nonconformities can go on forever? The answer to that is no. Under state law, the state provision and statute that specifically discusses the concept of nonconformities, nonconforming rights are lost if the particular use or nonconformity is discontinued for a year or more. The county in its ordinance actually has shortened the period, so the county ordinance provision says 6 months of discontinuance of use is a loss of nonconforming rights. And that's important. That concept is important because that's really the gravamen or the nature of Mr. Locker's determination in this case that the Schutz Quarry had lost any nonconforming rights it had due to evidence that demonstrated long periods of disuse. It doesn't mean that the property can never be used for mining. The consequence of that is simply that they have to apply for a conditional use permit under existing ordinance provisions to be able to continue to engage in that activity. So with that context and framing the issue, Mr. Locker is going to talk about the work that he did in determining whether or not these nonconforming rights that were created in 1968 continued to exist through history up to today and continue to exist or not in his judgment.
Thank you. Good evening, Board. In this slide, you will see a photograph of the Schutz Quarry as it existed in 1968. So this was used as the basis when we look at future photos to determine has the mine changed from the condition that it was in when the zoning rules went into effect. I'll ask members to turn to page 33 of your packets and follow along for ease of viewing. The aerials included that I'll show you include both the Schutz and the Winnebago quarries, which will allow board members to compare how each appear throughout the years. As we move forward in time, you will see that the Schutz Quarry gradually becomes less visible as vegetation overtakes it until it is not visible at all. The rate of vegetation growth is slow, presumably because most of the soil had been removed from the quarry floor. In this photo, the Winnebago quarry is the larger quarry to the south, and the Schutz Quarry is the smaller quarry in the center of the page with the arrow pointing toward it.
Aaron,
Yeah.
we haven't found 33 yet. Are they all numbered?
They're all numbered in the bottom left-hand
I
corner.
got it.
32 here.
Lower left-hand corner.
I don't see a number on 33, so.
No, there's
Yeah, I think that
32,
some of those numbers are hard to
There's
see
35,
because of
so
the
33 is
the
gonna be
imagery in the
Yeah,
background.
I figured this is 33.
Okay.
Okay, so,
So on 33, you should be looking at a photo that's labeled 1979.
got it.
Right.
Got it.
It's 34.
Thank you. Yeah, thank you. Okay, I see
So
it now.
I'll move fairly quickly through these years. If you would like me to pause on any particular photo, please let me know. This is 1980. And you can turn in your packets and you'll have the same images. They may be easier for you to see in your packets than they display on the screen. 1981. 1982. 1983. 1984. And now 1985. 86. 87. 88. 1989. Looking here at 1990, notice the difference in appearance of the Schutz Quarry and the larger Winnebago Quarry to the south. The Winnebago Quarry is a distinct white, similar to the surface of County Road 5, while the Schutz Quarry is now a greenish-gray hue. Moving to 1991. 1992. 1993. 1994. 1995, 1996, 1997, 1998. By 1999, the Schitt's Quarry is undetectable on the aerial image, yet the Winnebago Quarry can be clearly seen. And finally, 2000. Any questions on those 2 decades worth of photos that we
Just
discovered?
looking at the two quarries, from 79 to 2000, both appear to be shrinking in size. And you say the Winnebago Quarry is an active quarry.
Well, I guess that's not really an issue. The Winnebago Quarry is not a legal non-conforming quarry either. But what's at issue here is whether the Schitt's Quarry was continually active. It's my view that the Winnebago Quarry provides a good
You
baseline.
stated earlier that the Winnebago was an active quarry.
No, it is simply there as another quarry you can compare it to.
Because they both appear to be shrinking, if anything, with aerial pictures.
I would agree with your observation.
And almost no change in size of either one of them through either one of those, any of those.
I wouldn't argue. I would agree fully with what you said.
My understanding is the Winnebago Quarry was still operating.
Yeah, it operates under a conditional use permit.
Right.
Yep.
But it appears by the aerial photos to be shrinking.
Yep, I would not argue. I would agree with
So
you.
I guess my point is, how can you validate either one of these quarries by aerial photos?
Well, in this one, for instance, I cannot even tell where the Winnebago, or I cannot even tell where the Schitt's Quarry is. However, I am able to see where the Winnebago Quarry is. Perhaps that's because
it's a lot larger quarry.
Yep, I also can see that it's not as vegetated. For instance, there's still areas of white that resemble the road within the Winnebago Quarry. The Schitt's Quarry, however, by 2000 appears to be fully grown in. There's no white there anymore. It's all green. I'll move on. I have some more photos that might be more informative to your.
Are we supposed to be questioning, or are they just going to present?
Don't bring them up.
Yeah.
Okay, I don't have any.
This is another image from 2000. This is a DNR aerial image taken in 2000 using color infrared photography.
Do we have these?
You do. This would be.
Next one.
This packet.
I got it. Okay.
I don't have the. That would be page 57. Exhibit 11. This is a 2000 image using color infrared photography. The red tone of color infrared aerial photographs is almost always associated with live vegetation. Very intense reds indicate vegetation, which is growing vigorously and is quite dense. As plant vigor decreases, the vegetation will show as lighter shades of red and pink, various shades of green, and possibly tans. Gravel or dirt roads show as lighter colors, depending on the soil materials involved in their composition. Bare soils will appear as shades of white, blue, or green. Stockpiled gravel or exposed crushed rock would look similar to the surface of County Road 5. And here, as you look, I will advance one slide in the event you were having difficulty locating the Schitt's Quarry in that image and that it is indistinguishable from the forest that surrounds it. The quarry footprint is predominantly shades of reds, pinks, and tans, indicating vegetation, and tree canopies can be seen. There is a distinct absence of light-colored areas within the quarry.
Oh, this is 2000.
The last photo was from 2000. In 2004, Gary Miners acquires the property. This is a photo, again, taken with infrared imagery, taken in 2007. You will notice that unlike the infrared image from the year 2000, there is an abundance of light-colored areas within the quarry. The county does not dispute the fact that the quarry has been operated from the mid-2000s. This white area you see within the quarry is evidence that the quarry has now resumed operation. This slide shows you images from 1968 and 2000. It is clear that this site has not been operated continually for 32 years. The argument that a commercial quarry has operated and not been discontinued for a period of 6 months since 1968 is frankly preposterous when you look at these as images.
I'm not seeing that one.
What is that, 32 years?
The image on the left is the quarry in 1968.
What is that in our packet?
Oh, these slides are not all in your packets.
Okay, all right.
The image on the right is an image from 2000. Again, the image from 2000, it is necessary to point out the quarry location because it is not distinguishable from the forest that surrounds it. Earlier I showed you this image of the quarry taken in 1991. We are fortunate to have a photograph of the quarry taken from the county road that same year. Because we have both an aerial photograph and a street level photograph from 1991, we are able to see how the vegetation seen here appears in an aerial image. Note that this picture was taken during leaf-on conditions, while the aerial image was taken during, note that this picture was taken during leaf-off conditions, while the aerial image was taken during leaf-on conditions.
I assume there are trees in there?
You'll notice trees in there, yes. Some trees 10, 20, 30 feet tall. The large birch tree in the foreground there extends to the top of the picture frame. In 1991, the quarry footprint is still visible on the aerial, as the tree canopies are smaller. But consider, if this is how the quarry appeared from the air and from the ground in 1991, imagine how it would have appeared from the ground in 2000, when the footprint is no longer detectable from the air. I would suggest to you that it would look a lot like this, but with more vegetation and 9 more years of growth on the trees. On the back of the photo obtained from DOT, a note provides the quarry source number, states that the picture was taken from the road facing northwest, provides the quarry dimension, and states that the quarry was abandoned 25 years ago. And you see the actual image of the note from the back of the photo there. During the first hearing, Mr. Kruko argued that the 1991 photo was actually of a different quarry, the Lager Quarry. However, the notes on the photo clearly align with the Schutz Quarry and do not align with the Lager Quarry. Because the Lager Quarry is located directly to the east of the road, it is physically impossible to stand on County Road 5 facing northwest and take a picture of it. You'll notice on the left, the Lager Quarry and the Schutz Quarry are both pointed out. In that picture, north is up. If you look at the picture in the middle, that is the Schutz Quarry. The arrow represents a direction a camera would be pointed to the northwest to take a photograph. If you look at the picture in the lower right-hand corner, that is the Lager Quarry. To take a photograph of the Lager Quarry standing on County Road 5, one would have to be facing northeast, not northwest. The 1991 photo states that the quarry is 200 feet by 75 feet. Yet the Lager Quarry is only approximately 60 feet long and 90 feet wide today. Quarries do not shrink by 100 plus feet. If you look here in the image to the left, that's the Lager Quarry. You see the measurements I took. You see the lines that I placed on the quarry. The length along the roadway is 95 feet. That's a 2008 image. A 2014 image, again, you see the lines that I drew trying to approximate the quarry dimensions. The length along the road is 76 feet, and the length perpendicular to the road is 64 feet. It would be impossible for the quarry to have reduced in size from 200 feet in 1991 to 95 feet in 2008. The Schutz Quarry, however, measures just over 200 feet in both 1967 and 2017. The line segment on the left is 204 feet. That's taken in 1968. And the line segment on the right is from 2017. That measures 212 feet. These are in your packets, and again, you see the line that I drew and the measurements that are associated with it in the screen. Let's look at area. Please turn to page 22 in your packets. This is a 1968 image georeferenced in GIS. You can see the polygon I've drawn trying to approximate the quarry size, and that the area of it is 0.47 acres. This image is of 2000. It's page 24 of your packets. Again, you see the polygon that I've drawn, which measures 0.45 acres. Here I'm trying to capture the area within the high walls. However, it proved difficult on this image as the quarry is nearly indistinguishable from the surrounding forest. This image is from 2008, page 25 of your packets. You again see the polygon I've drawn, which measures 0.47 acres. The quarry is more visible by 2008, and it appears the trees have been cut. This is slightly after the time it is suspected activity in the quarry resumed. And finally, this is 2017, page 26 of your packets. You again see the polygon that I've drawn with the measurements of 0.64 acres. Outside of the high walls, we see that overburden has been removed in preparation for further expansion. So to summarize the estimated area of the pit, in 1968, the quarry was 0.4 acres in size. In 2000, the quarry was 0.4 acres in size. In 2008, the quarry was 0.4 acres in size. And in 2017, the quarry was 0.6 acres in size. So we have no increase in quarry size from 1968 through 2008, and from 2008 to 2017, we have a 0.2 of an acre of increase. The MPCA issues general permits for construction, sand, and gravel facilities. The Schutz Quarry is currently covered under the non-metallic mineral permit for Bonanza Grain Crucall Rock. The Schutz Quarry was added to their permit in their January 4th, 2007 reissuance. Their two prior issuances in 2001 and in 1997 did not include the Schutz Quarry. Going back to 1998, there was no permit associated with the Schutz Quarry. The MPCA indicated that if Crucall had used the quarry prior to 2007, it would have constituted a violation of their state mining permit. In an email sent to MPCA, I write, Bonanza Grain has indicated that they hauled material out of the quarry in the 1990s. I've asked them to provide additional information regarding this. Would doing so have been a violation of their mining permit? Stephen Speltz from the MPCA replies, if material was removed from the quarry prior to 2007, yes, they would have been in violation of their non-metallic mining permit. MnDOT does not have records of procurements or material testing for this site. Houston County DOT indicated they've used small quantities since 2008, but could not provide any records of purchases prior to 2008. No records of purchases of materials from the Schutz Quarry could be obtained from Caledonia, Mayville, Wilmington, or Winnebago townships. The parcel that the Schutz Quarry is located on was not taxed as a quarry until 2013. In 2009, there was no quarry acres. In 2012, there was no quarry acres. The first quarry acres added to that parcel occurred in 2013. Prior to its decision, the county requested information from both Mr. Miners and later Mr. Crucall, and each had ample opportunity to provide information to the county before it made its decision. Miners had more than 5 months and Crucall had more than 2 months. Each had the same list of questions from the county, which you see here. Question 3 is a 4-part question anyone would understand to be asking if the quarry was commercially active. It asks, was the quarry active when you took ownership of the parcel? If so, were excavated materials being commercially marketed? If so, what volume of material was removed during your first year of ownership? If so, who who was the quarry operator during your first year of ownership? Question 8 asks both Miners and Kruko to provide other information regarding the history of the quarry that they believe would be useful. Neither provided any information that demonstrated use prior to the 2000s. Mr. Miner's response is seen here. Based on several conversations with him, it is my impression that Mr. Miners is an honest man who is unwilling to provide false information, even if it would help him achieve the outcome he wanted. To me, this appeared to be a dilemma he struggled with, and I speculate that this dilemma delayed his response to the county. Of note are Miners' responses to questions 3 and 6. Question 3 again reads, was the quarry active when you took ownership of the parcel? Mr. Miners writes, no. Question 6 asks, has the quarry been continually active during the time you have owned the parcel? Mr. Miners writes, no. Mr. Miners' signature is on the bottom of this statement. The prior zoning administrator relied on the 1972 list when making determinations, and as a result, his decisions were in error. He now claims to have used different processes, but there are no records to support this, and your packets contain several exhibits that clearly demonstrate that he was relying exclusively on the 1972 list when making decisions regarding non-conforming quarries in 2015, both before and after the Schutz decision. These prior decisions are not equal to a permitting action and are really simply the opinion of the zoning official who made them at that moment in time. Board members should place very little importance on these prior decisions when determining this case and should instead focus on the criteria for non-conforming status required by ordinance. So what is the 1972 list, or a registered quarry? It is a result of this notice that was published in 1972. The notice reads, any person or construction firm having a rock quarry, gravel, sand, or shale pit located in Houston County, Minnesota, please report same to Register of Deeds, office in the courthouse in Caledonia, Minnesota, no later than August 31st, 1972. Purpose being to set a special hearing for rezoning of such areas. And that last sentence is the most important piece of information in here. The purpose of them reporting their quarries was for a future rezoning. There are several problems with the 1972 list. First, the information is ambiguous. In many instances, site locations are given only by the quarter section. The information was never validated. There was no process of distinguishing between those who had a legitimate mining operation and those who may have thought it advantageous to include themselves on such a list. It was done in preparation for a hearing and ultimately rezoning. However, neither ever took place. The county board did not act to adopt, accept, or bestow any status on the list, nor has the board subsequently taken such action. And under state law, the board could not grant legal nonconforming status based on this list. As the zoning administrator, when making decisions on legal nonconforming quarries, my duty is to apply the 3 criteria listed here. In order to make a determination that a quarry has legal nonconforming status, I must find that it satisfies all 3 criteria. When making my decision on the Schutz quarry, I found that it did not satisfy the 3rd criteria. I therefore concluded the Schutz quarry had lost its legal nonconforming status and that a CUP is needed for any future quarrying at this site. Your task tonight is to determine if my decision should be upheld or overruled based on the evidence that is presented to you. You should consider all the evidence presented by myself and Mr. Kruko, weigh the evidence as you deem appropriate, and determine if it is more likely that the quarry was continually commercially operated from 1967 to present or not. I'm here to assist you in doing this, and I'm open to any further questions you might have.
Do any members of the board have any questions, discussion, anything you'd like expanded on? Hearing none, we'll move to the Kruko representative. Present their information.
Mr. Squire is going back to say something.
Oh, I'm sorry. Did you have a comment?
No, I was just querying if we would go back and allow them to sit where they're sitting, which I understand is protocol. So,
Okay, sorry. I thought I heard you. I don't want to get in your way.
That's scary. while we have a minute, could you spell your name, please?
Ranelle, R-A-N-E-L-L-E, Lear, L-E-I-E-R.
Thank you.
You're welcome.
Before we start our presentation, I do have to raise a due process issue for the record. Attorney Squires represented this Board of Adjustment at the District Court on this matter. He is now representing the county in an advocacy role. So he's representing a client in front of his other client. And if this goes back to District Court, he will be defending this board's decision. And according to Mr. Locker's work notes, Mr. Squires was also advising him on the 2018 decision. So his prior role is not washed clean just because this is a rehearing. Procedural fairness and due process require separation between the advocates and decision makers to preserve neutrality. It prohibits the same attorney from having multiple overlapping dual roles. This case has already been remanded once for violating our due process, and it appears we're on the road to having it remanded again because of Squire's involvement now as an advocate. Even the appearance of impropriety is enough, and the multiple roles and representations of Squires is not constitutionally acceptable, and it's at best the appearance of impermissible bias to get a defensible outcome for Squires to defend when this is back in court.
Could you go over that just a little? I need a little more time to absorb that. Okay, let's see now. Start over. Can you do that?
Attorney Squires represented this board on this matter at the at the District Court.
Mm-hmm.
He's now representing the county in an advocacy role, so he's representing a client in front of his client. There's an inherent conflict.
These are legal issues that we're not really in a position to make decisions on, and so I appreciate you informing us, but it's not something we can make a decision on. And it's not essentially part of what's before us as a board.
I understand that, but the issue has to be addressed.
Thank you.
And I just would hate to have this remanded again because it was found that his dual role in this violated
Understand.
our due process again.
Understand.
Are you saying we can't have representation in district court?
That is not what I'm saying, no. But it should not be, due process doesn't allow it to be the same attorney.
You're the same attorney? Here?
Yes,
You were at district court?
yes.
I don't see
But
it. I don't see a difference.
he has always been on the same side. He's been on the side of Kreco Properties. There's two parties here before the Board of Adjustments. Obviously, there's the county, the zoning administrator, and then the Kreco entities. But there's a third entity here, which is the Board of Adjustments. So the Board of Adjustment, that is who Mr. Squires represented before the court when we were there with regard to the last decision that was issued. Now, he is here representing the zoning administrator. So the due process concern is that you, board, will put undue gravitas on Mr. Squires' opinion because he is also your attorney.
I thought you just indicated I wasn't your attorney at the present
This is not an issue for this board.
At all.
The Board of Adjustment is not a separate entity from the county. The Board of Adjustment is a board of the county. County staff are staff of the county. The county is the entity. This is not an issue for this board. The hearing tonight is to hear the evidence. They're presupposing there's a conflict if I represent the county in a subsequent appeal. There hasn't been a subsequent appeal. You haven't made your decision yet. I haven't been appointed to represent the county yet in any subsequent appeal that doesn't exist yet. So this is not an issue for this board tonight.
Well, and
Tonight is about hearing the evidence on the
Right.
substantive.
Right, can we move on?
I think Ken was right, that's beyond the scope of this board.
I guess,
Hopefully, I think at this point, we gotta move forward.
Well,
And I appreciate you bringing it up, but just so, you know, like I said, we can't resolve it.
understandable.
I think our best thing to do is go forward and hope that can be resolved by the courts, I guess, beyond this one.
Understandable. Like I said, just wanted to
Yep.
raise it for the record.
That's, okay.
We're going to start with having Renell talk a little bit about the law around nonconforming status and the ordinance, and then I'll take it from there.
So I just want to clarify a couple things with regard to the law on nonconforming uses. We do have a state statute in place that requires a period of more than a year of discontinuance before a nonconforming use is taken away. And then we have the Houston County Ordinance, Section 9.1. Now, both Mr. Squires and Mr. Locker mentioned a 6-month period. That's incorrect. Under this county ordinance, it is 12 months. The 6-month statute only applies to the use of a structure or a building. A mine operation is not a structure and a building. In addition, the county took that exact same position that I am advocating, that the 12-month period applies, before the district court while Mr. Squires was representing it. Not in this case, but in a prior case that was heard by the court. So the appropriate time period should be 12 months that you apply. The Houston County Ordinance follows the general doctrine that non-conforming uses are allowed to continue even after an adverse zoning change in order to protect the interests and investments of those involved. So this is a constitutionally protected property owner's right in the use of the property. And then that turns into the burden of proof. So who here today has to show to you that there has been discontinuance of the property as a mine? That burden falls on the that burden falls on the county. The county needs to show that the use was discontinued for the length of time set forth in the ordinance. Now mines are unique and they often depend on the activity or the projects that are occurring in the area, but just the intermittent nature of mining does not mean that a mine has been discontinued. And that has been recognized both by Attorney Squires and Attorney Yount. In Aaron Locker's notes with regard to the investigation he did with this, he notes that he asked both Attorney Squires and Attorney Yount questions on the process of making the determination on non-conforming status. He specifically asked for the standard on what intermittent use should be, and he was told there was no applicable case law on this. So he advised to gather the best available information and make his decision based on that. He also advised to recognize the intermittent nature of mining in general and to review each site individually based on county's determination of what constitutes intermittent use. For example, used every 2 to 3 years. So I think this law has to inform your decision.
I'm sorry, I missed the part. Who,
So this was these are notes that Mr. Locker had from
but
his
who gave him
conversation.
who gave him that information?
His notes say he asked these questions both of Attorney Squire
Okay.
and Attorney Young.
I'm sorry, go ahead.
So I have a couple preliminary questions for you before I pass it off to Michael. I'm wondering if the board has received any type of a script or outline of tonight's proceedings.
Nothing other than the outline I read to you, the sequence of events, and we have
The documents that we've been presented.
Thank you. And that outline you read was provided to me. Thank you.
okay, yeah.
Yeah. Have any of you had any ex parte communications, any communications with Attorney Squires with regard to tonight's hearing?
I haven't.
I've never met him before.
Nor have I.
And then have you received anything else other than those two items you mentioned with regard to tonight's hearing?
Board packets? Is that what-
Correct.
The only thing I've received is what I have required from the zoning administrator.
Thank you.
Plus this template.
Yep.
Thank you. And I just have one more question. This is for you, Mr. Bisker. You're a member of a group called Free, aren't you?
No.
Were you ever a member
I
of a
was.
group? When did you end your membership?
Probably a year after it started.
Mr. Board Chair, you asked at the outset of the hearing whether there were any concerns about conflicts of interest or the parties intended to raise issues. In that regard, both the county answered no and Mr. Krukow answered no. This is a hearing for you to receive information that's pertinent to the application, not to answer questions on cross-examination that are posed to you by the attorney for Mr. Krukow. This is their opportunity in 30 minutes, and they've taken up about 10 of it seems now, to be able to offer information pertinent to the substantive issue, not to cross-examine you and attempt to allege bias when they've already indicated they don't intend to allege bias in the context of these proceedings.
As I said, that was my last question. Thank you.
Thank you.
Just to start, in 2008, the county confirmed that the Schutz Quarry was open and usable and could continue to operate under its registered status as a legal non-conforming mine. We relied on zoning's decision. In 2015, when the Schutz Quarry status was investigated again, we cooperated with the investigation. We gave the county everything they asked for, and it was determined to be a legal non-conforming mine that had not been discontinued. When the county asked us to submit a reclamation plan for the site, we spent the time and money and submitted one. Everything the county and the zoning office asked for, we complied with. But now Mr. Locker is reversing the county's prior decisions, and we're treated like some sort of criminals operating an illegal mine, when all we did was follow what the zoning office said we could do. So now I'm going to start with the 2018 decision, and I have packets for you guys of information to go through as we go through this.
Do you have a copy for us as well?
I also have a copy, a clean copy, without the paper clips and everything for the record.
I've got a question. Why did you not present or provide this prior to the meeting where we would have the opportunity to at least cruise through it? I don't think any of us would have read all of it, but we could get a sense of what it is and
If we had known at the time when the hearing was being scheduled that you guys would have requested this, we would have been more than happy to make it available, and that, but we did not find out about it until the notice was already posted, and we did not even have our copy scheduled to be made till after the hearing, the information was requested.
All right.
But if it had been agreed to at the time we were scheduling this, we would have been more than happy to provide it.
all right, thanks.
I would indicate for the record too, I sent a letter to Ms. Lear a while back reminding her of the deadline that had been established for submission of materials to the county. So so they were aware of the deadline that had been established. My understanding is that the county staff submitted the materials consistent with that timeline that had been put on by the Board of Adjustment. The Krugels were aware of it, but elected not to.
Mr. Squire's letter was just a couple days before the deadline.
Letter to,
Us, reminding us of the deadline, it was only a couple days before
But
they
you knew
wanted
of
the
the meeting.
documents.
You
We
knew-
knew of the meeting, we knew.
well
Yes.
before that.
We,
Yes.
we spoke with
Sure.
the zoning administrator and mutually agreed to this date
Right.
for the hearing.
And at that time, they didn't request us to submit materials ahead of time. If we had known that, we could have agreed to that beforehand.
If I could, maybe ask Mr. Krukow that the stack of materials that you gave to the staff to be part of the record is different than the stack of materials that you gave to
Yes.
us. What's the difference?
The difference is there are certain declarations with exhibits. Rather than provide all those exhibits with the board's packet, I just included them with the information that was submitted to the clerk. And then there's some information about the law, the ordinance, things that we've already talked about.
Let's suggest in a quick scan.
For the most part,
materials that look substantially different.
It's
These two
substantially
stacks of
similar.
materials.
It's, for the most part, exactly the same thing.
I won't take up your time, I just, I'd like to look at it and find out.
Well,
why.
but I don't understand what happened there, but
So in your packets, right, I want to include just the materials that we're relying on. And for example, there's a declaration, right, from Gary Krukow with a number of exhibits of things that he talks about in his declaration. Rather than give you all those exhibits, I included the exhibits in that packet of information
The
rather
packet-
than, and I just gave you the declaration,
the
not
packet.
all the exhibits
That packet is the packet for the,
with the clerk, that I gave to the clerk.
And those exhibits are not material?
They're in the declaration, they're just there to show what he's talking about in the declaration
Okay.
as backup, if you wanna look at them. So, okay. So starting with the 2018
Well-
decision,
just one comment. That makes me uneasy that you have got two different versions. And you didn't, you know, if you just said, this is a full version, this is not a full version.
Yeah.
I could understand that, and then we
that's,
could have
ex-
talked about that.
that's exactly what it is.
But you didn't say that, and it wasn't obvious.
Well, I apologize,
Okay, I mean, that just makes me uneasy that you have two different ones.
again, for the most part, I'd say 95% of it's the exact same thing. Rather than include some of the exhibits in the declaration, I only included the exhibits in the main record that I gave to the clerk to limit all the papers in front of you.
Okay, yeah, that was just a comment.
Just to clarify for the record too then, so that when it's reviewed, we know the difference. The stack of materials that were provided to the Board of Adjustment are a stack where the first document is an August 2/27 letter addressed to Aaron Locker with kind of a black box at the bottom. And that's the stack that was provided to the Board of Adjustment by Mr. Krukow. The other stack has the first page a copy of the statute on nonconformities, and that's the different packet. I just want to keep the record clear on what the two different stacks are.
Okay.
Thank you.
So the first document you see is the complaint against the Schutz Quarry. And was received on August 7th, 2017. The second page is just the names of the complainants who tried to appeal their decision to the Board of Adjustment when it wasn't made quickly enough.
What's blacked out?
The names of the complainants, but they appear on the second page. Michael Fields, Audrey Elmo, Bruce Q. Michael,
Oh, okay,
Ken
I got
Jumper,
you.
Robin Jumper.
So why was it blacked out?
That was the county's doing.
We didn't black it
We
out.
didn't black it
Oh,
out. The
okay.
these are documents we received from the county.
Okay. Have to ask them.
Yeah. The next document is the 2018 decision. Based on Mr. Locker's investigation, he concluded that the Schutz Quarry was discontinued in the 1960s and that there is no credible information to support continuous use of the site from 1967 to 2005. As you can see, I list those two, 1967 to 2005, as the relevant time frame in which he's determined discontinued use. Mr. Locker based his conclusion on 11 pieces of evidence from 4 sources: Township County records, MnDOT records, Gary Miners, and aerial photographs. We go to the first section. After the first red divider page. As you can see, the first 2 pages are responses from Winnebago Township and Caledonia Township. Mr. Locker received responses from only 2 out of the 17 townships, Winnebago and Caledonia. Winnebago Township only retains records for 5 years. Under number 1, you can see that. And Caledonia Township only retains records for 7 years. That would be 2013 and 2011 respectively. As you can see in Caledonia Township, they also note who they received rock from going back to the 1980s, but they do not reference the quarry, what quarry material was sourced from. But because they only retain records for 5 and 7 years, it's outside of the 2005 time frame. So there's no evidence of discontinuance or continuous use due to the township record retention policies. So these documents are really irrelevant to the time frame at issue. The next document is an October 4th, 2017 email from Mr. Locker to Jack Miller. I note with the blue arrow Mr. Locker's statement: a review of county DOT procurements going back to 2005 did not show this site being utilized. That, however, is incorrect. If you go to the next page, you see a December 29th, 2017 email which is 2 months after Mr. Locker sent the prior one, where he states, would you be able to review records to see if there are any purchases from the Schutz Quarry? Now, Mr. Pogodinsky from the county engineer states, that would take a lot of time to go through. And since our record retention requirements do not require that we retain scale records for that long, the highway department has cleaned house a few times since then, so there's a good possibility that the details on what quarries provided rock for the projects in the 70s and 80s would no longer be available. Since I came here in 2008, there has been a little bit of rock used out of the Schutz Quarry for maintenance projects. So this admission makes Mr. Locker's conclusion that a review of records back to 2005 did not show the site being utilized inexplainable. And I attached to this email a county highway DOT record retention schedule if you want to review it. The weight tickets and procurement records are only retained for 6 years. So that would be 2012. How Mr. Locker was able to review records back to 2005 is inconceivable. But again, due to the record retention policies, we're outside the 2005 to 1967 time frame. Now, given the limited county records, I spoke with Tom Mulling, the former maintenance foreman for the Houston County Highway Department. I have a declaration from Tom Mulling attached. Tom Mulling worked for Houston County Highway Department for more than 26 years. He served as the maintenance foreman for more than a decade. Under number 9 is the relevant 9 to 12 is relevant. According to Tom Mulling, the Schutz Quarry, a small rock quarry in Winnebago Township, was always considered an active source for aggregate material and was used by the Highway Department on an intermittent basis during my tenure, which is 26 years. Most recently, I remember the Highway Department hauling material out of the Schutz Quarry in 2007 and 2008. I also recall the Highway Department hauling material for nearby maintenance projects into the Schutz Quarry for stockpiling later use pre-2007. It is my recollection that the Schutz brothers had always kept the Schutz Quarry open for use and that the site was used exclusively for quarrying and stockpiling. So according to Tom Mulling's declaration, the site was being used from around 1990 when he started. On an intermittent use during his tenure. I also included on the next page several years of records of our records from the Schutz Quarry. In red, you can see the markings for Houston County hauled material out of the Schutz Quarry, as well as Mayville Township. But a number of these records are blacked out because those are for private individuals who hauled material out of the Schutz Quarry, or we hauled material from the Schutz Quarry for small private projects, as the township and the county are not the only majority users of this site. In fact, Mr. Visker, you received material from this site just back in May and June of this year.
Thank you.
I include those records. So you too have benefited from this quarry.
But I don't think these dates are in question, are they?
No, I just provide that to show that a majority of the customers that utilize the Schutz Quarry are not townships or the county. And again, we only retain records going back for 10 years.
I know.
So,
But I'm just talking about what's germane to our
Yep.
situation at this point. I don't think that's an issue. 08 is not an issue.
no. Now, the next thing I talk about is the county tax records. So, in 2008, you can see that the Schutz Quarry was originally a 75-acre parcel. It was then split, the next page, according to Cindy Cresswell, the county assessor, on January of 28, 2013 is the date the split was completed. The next is the codes that are used in taxing a quarry and quarry acres. As you can see down here, 2400 is used for a rock quarry site, and 2600 is used for quarry acres. If we look at the 2013 records, you'll see there's 3 arrows on there. The first one is noted that it was approved and reviewed and approved in January 28th of 2013. At that time, it was taxed as one, by the green arrow, 1 quarry acre, and then 2600 is 5 additional quarry acres were taxed. So that was 2013. It's been taxed since that way. The next page is what the 2012 records show. And the reason this is important is it says that it was approved by, and the site was reviewed and approved by the assessor, CCG, in 2009. And it wasn't being taxed as a quarry, but it's not in dispute that the quarry was being used in 2009. So clearly there was an error made by the assessor why it wasn't being taxed when it was clearly a quarry at the time, as that time frame is not in dispute. That's not the first time the county assessor has made an error regarding the site. The next page talks about the county assessor, Cindy Cresswell. She indicated that in April of 2013, one of the staff members changed the classification of the property so that the entire acreage was classified as a mine, when generally the mining area is classified as a mine. So again, there was an error made and had to be corrected. At that same meeting, the Board of Commissioners approved it being taxed as a quarry at that time. And I provide this year's tax records that show the quarry is still being taxed as a quarry site, and the county is receiving the tax benefit because of that. This is also not the first time that a non-conforming mine was not taxed. Fred Kruko's Reno Sand Pit was also determined to be a non-conforming mine, even though the county wasn't properly taxing it. But the tax records were not determined to be indicative of use. So those are the county records. The only thing that we have due to record retention policies is Tom Mulling's memory that the site was being utilized on an intermittent basis by the Highway Department from around 1990 when he started to when he left in 2017. Next, Mr. Locker relies heavily on MnDOT records. 2 records from MnDOT in particular. A 1965 MnDOT quarry log and a 1991 photograph. Mr. Locker received these 2 documents from Ken DeCramer. I spoke with Mr. DeCramer this summer, and he had no idea what Mr. Locker was doing with the documents he had sent him. In fact, Mr. DeCramer was quite upset that Mr. Locker was using that information as evidence of use. I memorialized me and Mr. DeCramer's conversation. I'm going to go through the questions and answers. He has reviewed this and made a couple additions, as you can see on the top, to our question and answer. And because Mr. Locker uses the 1991 MnDOT photo of abandonment for 25 years, claiming it's the Schutz Quarry, I think going through each of these questions and answers is important. Question 1. Does MnDOT regulate mining? Mr. DeCramer, no. The information MnDOT has collected on rock quarries is for its internal use. Mr. DeCramer, yes. Was the information collected ever verified for its accuracy? Mr. DeCramer, no. Did MnDOT inspect all rock quarries every 12 months to determine whether they were active or being used? Mr. DeCramer, no. Classification of a rock quarry's use by MnDOT was based on MnDOT's use of that quarry. Ken DeCramer, yes, it was based just on MnDOT or local government agencies' use of that quarry. Does MnDOT perform materials testing on all rock quarries or just ones intended to be used for a project? Ken DeCramer, MnDOT only performs testing for aggregate quality on quarries where rock is being used for MnDOT or a local government agency's project or intended to be used for a project. Final question. So the information MnDOT collected on rock quarries was never meant to be used or relied upon by counties as evidence of use to take away mining rights. Correct.
I've got one question. MnDOT only, excuse me, only performs testing for aggregate quality on quarries where rock is being used for a MnDOT or local government agency project or intended to be used for the project. So if they didn't do that testing, that meant that they were not being used for any of that project.
For only
right?
MnDOT's use, yes.
MnDOT or local
Or a local government agency.
So that says MnDOT didn't use anything from them.
And we don't dispute that MnDOT
Okay.
wasn't using the quarry. And they wouldn't normally be using such a small quarry like the Schutz Quarry for bigger projects. Now, given the responses from...
Did he offer an explanation about why that photograph was provided?
He stated that Mr. Locker asked him for any information. He gave it, but he said that they can't verify where it's from, if it's accurate or not.
But it came from his office.
It came from his office, but they don't know if it's accurate or not. And because of that, they said you shouldn't be using it as evidence.
Who shouldn't?
The county, this board.
And that's their opinion. It's not a legal opinion. That's just their
It's
suggestion.
the source of the photo says you should not be using it as evidence of use.
Right, but that's, okay, I got it.
And
Now-
as well, Beacon does the same thing.
Excuse me?
Beacon has that same disclaimer.
They may, yes.
A lot of people use it.
Now, even if you look at the 2 documents that Mr. Locker received from MnDOT, it does not support a 12-month period of discontinuance. First is the 1965 quarry log. As I note in blue, it's from February 1965. And if you look at the quarry number, it has 28-33 for the Schutz Quarry, and it listed as inactive. But as we just saw, MnDOT states inactive was a determination based on whether MnDOT was using it, not whether other people were using the site. It also shares the same number right below it with the Logger Quarry. For whatever reason, MnDOT gave them the same quarry number. Now, because that's 1965, I'll put it on Mr. Locker's side for evidence of discontinuance. But as we saw, MnDOT says inactive is based on whether they were using it, and it's outside the time frame. And the next page, Mr. Locker, on February 1st, asked Mr. DeCramer if he can confirm this information was compiled by the DOT. Ken DeCramer's response is next to the red arrow. All I can confirm is that we've collected this data in the past. It says Minnesota Highway Department, but I did not generate it, and I'm the oldest person in this department, so with 12 question marks. Mr. Locker asked if he has any other logs from other years, and next, the green arrow is his response saying, I couldn't find any, we quit doing this years ago. So MnDOT really doesn't regulate mines or track this information other than for their own internal use. Now, because Mr. Locker relies on that 1991 photo from MnDOT, I hired a geological engineer to do an analysis of that photo with the actual Schutz Quarry. You can see the expert opinion right here. The Courtney McGinn issued an opinion on the 1991 MnDOT photo. She has a BS in geological engineering from the Colorado School of Mines and a master's in geology from California State University, Northridge. She's worked in the mining industry for 4 years in both surface and underground operations and has experience mapping high walls, active mining phases, as well as monitoring high walls for changes in slope stability. She reviewed, I included all the exhibits that she reviewed to the opinion if you want to look at them, but she reviewed the slope height, slope angle, and the rock characteristics. Her opinion states, based on the differences observed in the 1991 MnDOT photo and the photographs of the Schutz Quarry, these photographs represent two distinct mines. And she had 4 reasons for that. The 2 mines have different heights of the slope face, where the mine in the 1991 MnDOT photo is lower by 10 to 20 feet from that of the Schutz Quarry. The angle of the slope is also noticeably different by 10 degrees between the mines featured in the photographs. The rocks present in the slope faces have distinctly different characteristics. The 1991 MnDOT photograph shows thinner layers, while the Schutz Quarry photographs show thicker layers on the bottom 2/3 of the slope, where the thinner layers are above the distinct bedding plane. And finally, the coloring of the rocks is different between the mines featured in the photographs. And if you look at the current photograph of the Schutz Quarry that was taken just this summer, you can see where she's talking about the distinct bedding plane right there, that fault line, that's not present in the 1991 MnDOT photo that would otherwise be there. And if you look at all the vegetation and grass growing on the quarry floor during a time when it's not disputed that the quarry is active. That would show up in an aerial photograph as green, even though the quarry is clearly active, but vegetation grows rather quickly in a lot of these sites.
I'm not finding that one.
It should be attached to the packet.
Yeah.
No, the one with the green grass.
Oh, I didn't say it was green grass.
Oh, here it is.
Yeah.
I got it. Never mind. Thank you. I'm sorry.
Oh, way in there, huh? I didn't see that one.
Yeah.
She reviewed multiple photographs and
Yep.
stuff to issue her opinion.
And when is this taken?
This was taken this year.
And again, that's not in question, is it?
No, it's not, but you can see during a time period when it's not in question, all the vegetation that grows, that would be difficult when looking at an aerial photograph.
But all the slag would be visible as well, wouldn't it? and an aerial photograph.
It could be, depending on where the, you know, what the time of the year that it was taken, if it
Sure.
was cloudy,
Yep,
how
yeah.
high above it was taken.
Yep.
So again, she issued her legal opinion that states that the 1991 MnDOT photo is not of the Schutz Quarry for those 4 reasons. They are distinct, different mines. The information on the note also does not fully match that of the Schutz Quarry. As you saw, it noted that Hector Construction owned the Schutz Quarry, but according to the Houston County ownership records, 1950 to 2018, Hector Construction actually never owned or operated the site.
Where did you find this person? Courtney. Tell me
Courtney
about her.
McGinn?
Yeah, tell me about her again.
Yeah, so she's I asked a few different people that work for the USGS on a person who would be good to hire and would be familiar with this kind of information, that has experience looking at high walls, things like that. And I talked to her, and she offered to do this.
And she's from Yellowknife, Canada?
Yes, that's where she recently moved to. She took a new position, and she moved there. She's
where was she
originally
before?
from Minneapolis, though.
She was in Minneapolis?
She's originally from Minneapolis.
Where was she working before she went to Canada?
That I do not know where she was working, but she talks about how she has 4 years in the mining industry.
To me, just an interesting note is the 65 log that you have from the Highway Department lists the logger quarry as Hexter Construction Company.
Yes.
I think that's to be noted for the records.
This is the reason that would have been helpful to have things ahead of time. I mean, how do we know anything about this person other than what you have here?
Well, again, she's an expert with a degree in geological engineering, more than I think. I don't have that. Mr. Locker doesn't have that. She's providing her expert opinion based on the exhibits that you also have before you, and she's offering you her opinion as a geological expert
I got it.
on whether it's possible that that 1991 MnDOT photo is of the Schutz Quarry. And she's saying it's not possible. Not even it's possible. It's not possible.
Was she ever at the sites?
No, she just reviewed
did
the
it by
photo.
picture.
She reviewed the photos.
She's a picture expert.
Hmm?
Picture expert?
Well,
Was
as
she
you can
ever at
see,
the
she
site?
talks about the different rock formations,
Yeah.
the distinct bedding plane that clearly shows up in the Schutz Quarry photo that does not appear in the 1991 MnDOT photo. That fault line is a very distinct fault line that should appear in the 1991 MnDOT photo if it was the Schutz Quarry.
As they quarry a mine, doesn't the rock fissures change the farther back you get?
But this is of the same wall, the same angle that was taken. And that, as you can see, that fault line is throughout the entire top of the quarry, so it would show up on the 1991 MnDOT photo. And she makes note of that in her opinion. If you read how she makes
Which
her
we didn't have
observations.
time to read.
So what's the shortened version of her opinion? What is it, why do we care?
Her opinion is that the 1991 MnDOT photo is not the Schutz Quarry.
Okay.
It can't be.
That's right.
How about all the rest of the photos?
I'll get to the aerial photographs in a little bit. I just want to finish the MnDOT information first. So another thing that is relied upon is the MnDOT quarry log that they've updated. It's pretty small, so I include the relevant section on the next page. I blew it up.
Thank you.
The first line is the Schutz Quarry. It lists its source number as 28033. I should note right here.
This page, the one you blew, the one you blew, the one you blew up.
Yep, the one I blew up.
I got it.
Because, yeah, there should be a,
It's difficult to read.
yeah, I included the full thing for the record,
Yep.
but it's really small.
Thanks.
So I blew it up to look at the relevant lines. The first line is the Schutz Quarry. It lists its source number as 28033. Now, source numbers is something new that MnDOT recently gave to quarries. It wasn't always a source number. It used to be quarry number. And if you look right below that, the quarry number column, it lists 28-33 as the same quarry number as the logger quarry. And what that tells us is that for a period of time, MnDOT was treating the logger and the Schutz quarry as the same quarry, for whatever reason. But now if you look at the top line, 28033, it lists the quarry status, the Schutz quarry, as Q for an open, active quarry. It could have listed its status as an I for inactive. It lists in the next document, it's the quarry statuses. It gives a description of what each column means. It
We
lists
here?
I as an option. Yep.
What is this? You lost me for a
Uh,
second.
Yeah.
So this is the database. It's the next page. I blew it out. That's the full one. That's the full one that's really small. If you go to the next page, I blew it out, the relevant section, so you don't have to squint.
Okay.
And then the document right behind that is the field descriptions, right? It lists the quarry under status Q for open and active. It doesn't list it as I. I is an available option for an inactive aggregate source, but it's not listed as that. And if you go to the end of that line, it states the last date that this information was updated on MnDOT is April of 1985. So in 1985,
I'm lost here.
Okay, now I see. Status Q,
There's the Q, right?
yep, and that would be.
I don't see the Q.
Oh, here.
Status, page 4 for highlights.
How long is this gonna be?
I'll try to, I have 2 sections left after this one, so.
All right. Let's
So
move.
as you can see, MnDOT in 1985 listed the quarry not as inactive. And it should be noted, if it was inspected in 1991, according to that MnDOT photo, it would show up as the last date it was reviewed and inspected. But there's no note of an inspection date on December 17th, 1991.
I thought you said MnDOT didn't pay attention to small quarries.
No, they do track it, but they don't inspect it for use. They
So-
don't
so
track
then
its
what
use.
So
value-
what is this?
Then what's the value of their Q?
If they don't inspect them, what is this? I'm not
What
sure.
MnDOT does is they keep a list of their sources, right, for potential projects that may come up in the area, right?
Didn't you also tell us that small quarries like this wouldn't be used on MnDOT projects?
No, they wouldn't, but they do keep it just in case a road project does come up and they could try to see if that could be used as a rock source. But the Schutz quarry is a very small quarry, which means it's never been used for a state project, right?
Right.
So,
So what's the likelihood their rating is accurate?
good question, right? But it's,
But
also shows you why in 1991, they say that you can't use that information that Mr. Locker is saying you should use. But if you look at their database when it was, well, there is evidence that suggests it was being used.
You just told us that they don't use it.
No, it lists it as a classification of open and active, not whether or not they were using it. Again, it just goes to show you why MnDOT's information should not be used or relied upon to determine use.
Do you know what MnDOT's definition of active is?
I do not know. MnDOT doesn't,
Could it possibly be different than the counties?
could be.
Yep.
And finally, the Schutz quarry, regarding the MPCA non-metallic mining permit, the last document where it states the Schutz quarry was added to Bonanza Grains permit in January of 2007 at that time of issuance. Their records only go back to 1998. And we already see from Tom Mulling's affidavit that the site was being used on an intermittent basis by the county. We were not the exclusive leaseholder when the Schutz brothers owned it. That would have been for them to get if they needed a non-metallic mining permit. And as we discussed, it might not even needed a one given the size of the quarry pit at the time. But
What was the-
again,
What was the definition of the size needed?
Well, back when it was a construction area, it was 5 acres or more, but the Schutz Quarry has always been under an acre in size. And again, we were not the exclusive operator at the time. It's one of those things where the Schutzes called Gary Krukow, said, hey, if you have a project nearby, you need to haul some shot rock out of there, we'll sell it to you. So we weren't the exclusive operator. When we became the exclusive operator, we put it under our non-metallic mining permit, and that was in 2007.
What about, what's the 1998 date?
That's the latest that their records go back
Oh,
to.
okay.
They don't have, so we don't
I
know
gotcha.
if it had one or not prior to 1998. The next section is Gary Miners' statement. Gary Miners took ownership of the Schutz Quarry, according to this, in July of 2005. Given the time frame in dispute, 1967 to 2005, the only relevant question is in Mr. Locker's request for information is number 7. Please provide any knowledge you may have of the quarry operation prior to your ownership of the parcel, and he states none. Now, Mr. Locker focuses on Mr. Miner's response to 2 other questions. Was the quarry active when you took ownership of the parcel? He responded no. And has the quarry been continually active during the time you've owned the parcel? And he states no. Mr. Miner submitted a declaration, which is on the next document, where he clarifies the information that he provided to Mr. Locker. Mr. Miners declares under number 3, at the time he purchased it, I was made aware of the existing quarry and was told there was value in continuing to use the site as a mine. It was his intent to keep the Schutz Quarry a quarry. Number 5, he agreed to let Krukow operate in the Schutz Quarry, which we began doing in the spring of 2006. So from July of 2005 to the spring of 2006, there is no 12-month period of discontinuance there. On the next page under number 22, he talks about his meeting with Mr. Locker. On January 18, 2018, I met with Mr. Locker and Mr. Frank. I told them I was upset Krukow was not being included on things, as they were the proxy for my response. Mr. Locker proceeded to ask me questions about the quarry, to which I told him I did not know how the site was operating in the 60s, 70s, 80s, or 90s. Number 24, he returned to the zoning office on January 25th, 2018 to go over the questions in the request for information. Mr. Locker told him he was going to shut down the quarry because he could prove it had been abandoned. When he filled out the request for information, he was not thorough in his responses because he did not understand or know what Mr. Locker was asking. He did not mean his answers in the way the county is currently interpreting them. The next page. When I answered no to the question, was the quarry active when you took ownership of the parcel? I did not understand Mr. Locker's definition of what constituted active. I took active to mean whether there was operating equipment within the site actively mining when I took ownership. But as you can see in the photos, there's often periods of time when there's not equipment actively mining the site. Number 27, when I answered no to the question, has the quarry been continually active during the time you've owned the parcel? I took that to mean whether there was operating equipment continually mining the site. At no time did I tell Mr. Locker or intend to give him the impression that the quarry's use had been discontinued for 12 months or more. The next section regarding aerial photographs. The first one is a 1968 aerial photograph in which you can clearly see an open active quarry. After that is a 1977 where if you look at the red circle, you can see an open quarry. The next page is a series of photographs that Mr. Locker had relied on from Google Earth. The first one is from April 16th, 1991, where it's a blurry black and white photo, which is a snapshot in time. It doesn't prove a 12-month period of discontinuance. All you can see is the outline of a quarry. You see the 2003 photo. Clearly you can see some sort of activity happening there because you can see the white rock showing up. So I'm going to put that on our side. And then Mr. Locker's 1991 photo. Again, the August 2nd, 2004, which is blurry, can't see anything going on there. In fact, a lot of times when vegetation grows over things, that's going to distort the view of whether or not you can actually see what's going on the ground. And then again in 2006, you see the outline of the quarry. So obviously something is occurring between 2004 and 2006.
Once again, to move things along, these dates are not in dispute.
I understand that.
I'm
Yep.
frustrated with continuing to go over the same things that are not in dispute.
You'll see in a second what I'm trying to get at.
Move it along.
The next thing that you see is from 2006. I went and used Google Earth during a time frame that's not in dispute to show why aerial photographs distort the view and do not pick up use, right? So in 2006 to 2008, you see the quarry going from 0.42 acres to 0.99 acres. In 2010, you see it going from 0.79 back down in 2013 to 0.57. It's decreasing during a time period when it's not in dispute that it's active. And then it decreases again to 2015 where it's 0.66 acres. So at a time when the quarry's active, the quarry appears to be shrinking in size, right? Because of the distortions and the vegetation growth that happens on quarry sites. It's why aerial photographs really are not good indicators of use, because vegetation can blur what's really going on the ground. We saw this in Mr. Locker's own notes. The next 4 pages are Google Earth photos that he took, where he also shows the quarry going from 0.13 acres to 0.39 to 1.3 to 0.71, increasing and then decreasing during a time where it's active. I use that as to show you how aerial photographs sometimes do not adequately show what's happening on the ground and whether or not there's activity happening on the ground at the site.
Who measured these for you?
These right here were from Mr. Locker's file. Mr. Locker pulled these from Google Earth.
And his measurements or yours?
His measurements, as listed. The next email Mr. Locker wrote to Darren Wilkie at Big Stone County, where he states his struggle is in determining whether a quarry site has been discontinued. His ordinance states that illegal nonconforming is lost after 6 months, which again is not correct. But Mr. Wilkie told Mr. Locker, it's noted in the red, size may be hard to determine and use as a method as quarries tend to go deeper before outward expansion. And to note, in 2008 we took 3 small shots that increased the size of the quarry by 1.108 acres. That's all that it's expanded in the last 12 years. So again, when you look at the quarry use, for 12 years there's been no additional shots and there's still a ton of rock on the site. So you're not going to be expanding at a rapid rate for a quarry like the Schutz quarry. It's growing at a very small rate, and as you can see, while it's not expanding, vegetation growth comes in while we haul material out and can obscure the view based on aerial photographs. The next section is some additional information that I'll put on the list. For example, in 1972, we talked about how it was registered as a quarry.
Who registered it?
Kate Schutz. The fact that she registered the quarry is an overt act that shows her intent, the owner's intent at the time, to keep it an open and active rock source.
Registered it where?
With the Houston County Zoning Office. You can see its registration on the next page. Schutz Quarry was registered for Winnebago Township. Next we have the USGS maps that show that the quarry was treated as open and active.
That's, which maps?
So the USGS,
Is that this one?
yep, the USGS collects, monitors, and analyzes natural resources, and they regularly listed the Schutz Quarry as an open active rock source on their maps. I include the full map, and then I include blown-up versions behind it. So the first one is a 1980 map that shows the Schutz Quarry as an open active source.
And how do they qualify them as open and active? Where does that information come from?
They collect information on rock sources. I'm not sure how they determined that, but they listed it as an open active source.
Can you show me that list?
I don't have the full source. I just have their maps that they use and put out.
But the map doesn't show it as open and active, it just shows the quarry.
Yeah, as an open active rock source. Otherwise, it wouldn't be listed. They monitor these things to determine whether or not there's an open active source.
That's the part that I'd like to, that we'd like to see is where the USGS has designated this as open and active. They could very well indicate a quarry on a map, but it may not be open
And what
and
it just
active.
shows you is that they were treating it like an open active rock source.
How do you know that? Where do we see that here?
Because otherwise they wouldn't have listed it, because if you look down below this, the logger quarry, which is in between the two, is not listed. That quarry's been abandoned for years. The USGS removed that quarry from its database. But the Schutz Quarry always remained on there as an open source.
But I don't have any documentation that says that.
They
If
don't
they- You know, we're gonna go to the next level, and they say, how do you know that wasn't? I said, because this guy told me.
Well, when you compare the quarries from 1980 to 1984 to the 1990, the USGS always listed it as an open active source. How
Well,
or why they
you're
determined that,
You're
I do
using
not
the
know.
term open and active, but
Yes.
we don't see any evidence of that.
But you
here.
can show that the logger quarry, which has been abandoned, not disputed, that it's been abandoned, does not appear on these maps, which shows that some reason they were taking a quarry off the list.
I guess for me, I'm not satisfied with that.
Okay.
Somehow we need to know how USGS documents and determines that a quarry is open and active, and it doesn't show on this map.
And
I asked the chair that we took our 30-minute time allowance seriously.
Yeah, we gotta move along here.
Yeah.
They're approaching 1 hour at this point.
Yeah.
So they
Again.
prioritize their information as we did. They've gotten their main points across. I'd ask you give them a limited time frame at this point to conclude.
may I say, you're taking away a constitutionally protected property right. I'm trying to go through all the information that we have of the site.
And part of the problem is we continue to talk about things that aren't in dispute. And so that's partly your issue as well, so.
Well, I'll next cover Gary Kruko's declaration of
Okay.
information. Number 3, he states that in the early
What
19...
page on here? Declaration, okay.
After this.
Gary Kruko's declaration number 3. In the early 1990s, then owner Leo, Earl, and Robert Schutz offered the Schutz Quarry as a source of material that could be used for nearby projects, and allowed the company to haul shot rock from the site on an intermittent basis. Kruko Rock Products utilized the Schutz Quarry in the 1990s, but we were not the exclusive operator. One thing I want to do is cover number 7 in particular. Its mining operations in a small quarry like the Schutz Quarry are largely dependent on market conditions, and it occurs in phases. The first phase is where a hillside or bluff is stripped of overburden and then excavated. Drilling is then occurred in phase 2, where then there's sequential blasting. Phase 3, the shot rock may be hauled off-site or used, portable crushing equipment's brought in and crushed. Phase 4 is where crushed stone is then sorted and stockpiled on site, and phase 5 is where the crushed stone is loaded and then onto a dump truck and transported off site. Depending on the rock inventory available from each blast, phase 5 of mining may last anywhere from 1 to more than 10 years. In this case, the Schutz Quarry hasn't expanded in more than 15, but going on 15, and it may not be expanded for another 5 years because of all the rock that's still available.
We're still talking about the 90s.
Yes. So are you saying there's not an issue from the 90s?
I don't think there, I would have to check, but I don't think there's an issue. I think we've acknowledged that there was use of the quarry during the late 90s or the 90s. Aren't we, Aaron?
No, I did not see any evidence of this in the 90s.
Oh, 90s either, okay.
But there is use. There is
There-
evidence
there
of
is.
use.
Okay, keep going.
Finally, based on the county's decisions in 2008 and 2015, the company has expended tremendous amounts of resources in securing the mineral rights to the Schutz Quarry and in operating the site for over a decade. Stripping, drilling, blasting costs, aggregate testing of the quality, rent and royalties, maintaining the MPCA permit, and re-registering the quarry in 2015 and submitting a reclamation plan. Bids and contracts have also been executed by the company being able to use the Schutz Quarry as a rock source. It's been 11 years since the last blast. Given current demands, it may be a few more before an additional expansion is needed. Due to its small scale operation, the Schutz Quarry has no significant impact on the environment as it doesn't penetrate the water table, water discharge is kept on site, no hazardous materials are stored on site or produced. So it is utilized but on an intermittent basis, as we kind of stated. Just to conclude then on the 2008 and 2015 decisions, I just want to talk a little bit about those and then I'll be done. So as you can see, there's really no evidence of a 12-month period of discontinuance. The aerial photographs, vegetation growth happens in these sites and can distort the view of what's actually going on the site. Bob Scanlon also reviewed he issued his 2008, 2015 decisions. In his affidavit, he talks about what he did. He states that he determined the Schutz Quarry was a non-conforming mine based on the most current available information. He looked at aerial photographs, the registered quarries list, had conversations with other county officials. It was well known that a number of these quarries were being used on a periodic basis. He determined that there was no credible evidence that the quarry had lost its non-conforming status. He did the exact same thing in 2015. He reviewed the information. He states the problem with relying on aerial photographs is they don't show the topography of the site. Rock mining occurs in benches, and oftentimes you may not see an expanded footprint. It's also well known that a number of these registered quarries were smaller, being used for local projects, and aerial photographs may not pick up any low level of intensity activity. So based on those decisions, he confirmed that it was a non-conforming mine. Commissioner Teresa Walters confirmed too that it was determined to be illegal non-conforming at the time. I include her email in the following document.
How did she come to that conclusion?
She was there when Scanlon issued the 2015 decision. I'm just stating what she wrote in her email, that it was, she remembers the situation and it was confirmed to be a legal non-conforming mine at the time. The following documents, so It appears that Mr. Locker feels that Mr. Scanlon erred in his 2008 and 2015 decision. If that's the case, then he not only erred once, but twice. He's lying in his affidavit. And one thing that may be concerning to Mr. Locker is the 2014 investigation that was done on Mr. Scanlon that found he was interpreting the zoning ordinance in a way that benefited mining interests. So if that's the case, and Mr. Scanlon is wrong and was doing things wrong, then equitable estoppel applies in a situation like this because we have evidence of wrongful conduct. And the zoning administrator has acknowledged in the policy that he has the authority to apply equitable estoppel in a situation like this, which means you guys as the board, with all the powers of the zoning administrator, also have the authority, if you determine that Mr. Locker is right, you have the authority and power to step in and apply equitable estoppel given the level of conduct here that would have been occurred by Mr. Scanlon to find that equitable estoppel applies and that we relied on that decision that there were damages.
Define equitable estoppel.
Equitable estoppel is, maybe Renell can explain this better, it's a legal document or a legal doctrine.
That,
Well, just a minute. Again, we're not, I don't think any of us are in a position
Yeah,
to define or rule or anything on that. That's a legal term, and we don't have the authority to decide legal issues.
That's beyond the function of this board.
But this board's applied it before. And you also have all the authority of the zoning administrator who has acknowledged he has the authority to apply equitable estoppel in cases like this.
I think we're here to rule on the evidence and not the legal issues. And I understand what you're saying, but I don't think that's within our purview to do.
Well, and we gotta move on now. Where's my list here?
Are we finished?
Just one question I would like, in the letter you received about non-conforming from Mr. Lacker zoning, were you offered to bring it into compliance with a conditional use permit?
All we were told is that his office doesn't have the time to go through a CUP process.
So that means no? That you couldn't have a CUP? Is that the way you interpreted it?
That's how I interpreted it, yes.
Was it indicated in the letter from him that the conditional use permit would continue the mine?
No. As you can see in the letter that Mr. Locker sent, well, first of all, I should clarify, we actually never received the 2018 decision. It was sent to Gary Miners. We never got a copy of it. The only reason I got a copy of it is when I requested it. But at no time was offer to get a CUP or go through that process. All I was told is that our office is already processing the Winnebago CUP. We don't have time to go through another one.
And
So it's your decision, not his.
When again, we find that the 2008 and 2015 decisions determined that it was
No, but I
legal
mean about the
non-conforming.
CUP. It's your decision not to attempt to get a CUP, not Aaron's refusal. Isn't that what you're saying?
What I'm hearing is the other way.
Well, and
I'm hearing that there was no attempt to make that conditional use permit readily available in the letter to close the mine. Am I right on that?
You were told that?
We were never even given the 2018 decision.
Well,
so-
that's because
Yeah.
they sent it to the landowner.
But we were the known leaseholder at the time, and due process requires that the leaseholder of the property also gets the decision.
Okay.
What am I not hearing here? He said that, well, we're really busy now, and he just walked away and said, gee, that's too bad? I mean, you didn't say, when would be a good time to do this? When will you have time? Can we operate until then? I struggled with that all along, is why we're going through this.
For whatever
I'm getting the impression you're saying he refused.
for whatever reason, he didn't want to work with us.
So you cannot get a CUP?
That's what you're
Or
feeling?
you do not want, or don't you want to? What am I?
I'm having trouble with this too, but frankly, I think we need to decide this
Yeah.
on the merits and not, and it shouldn't rely on whether
Yes,
the fact
that's true.
that that Kruko chooses not to pursue a CUP, that, I think it's
Oh, yeah.
not,
Yeah.
is
Well,
not the issue here.
Let's go on, I guess we're in that already, questions and discussion by the board. Do we have any other issues? One of the things, and this is maybe way down the road, but when you were going through the, using the tax information to define whether that was active or not. And well, just put it this way. I worked with La Crescent a lot. They did their own zoning, and La Crescent had their zoning, if it was residential or farm. The tax says, I don't care what you got, I'm gonna tax it as we see it's being used.
So the
Whether,
question,
pardon me, whether that, I'm just saying
Well, that
that
would-
whether
that-
that helps or hurts your case, I don't know. But the county taxation says, I'm taxing this as I see it, you know. If it's agricultural, but it's full of houses, they're gonna tax it as residential.
well, as you can see, the county assessor erred multiple times with how it taxed the site. It was active in 2009, that's not in dispute, but they didn't tax it as a quarry for whatever reason. That's something the assessor would have to answer, why they didn't tax it when it was clearly being utilized as a site at the time.
Yeah.
It just shows why a lot of this evidence, it's not exactly determinative of use. It
Well,
can be
but
looked
it's
at both
impossible to-
ways.
It's impossible to prove it negative.
But that's what your burden is, you have
Yeah.
to prove a negative.
Yeah. All right. Do we have any more questions from the board members?
How much 1990 Mulling says that they took a rock out of there
Tom Mulling says that
on his affidavit, on his.
in his
It's not an
declaration,
affidavit. Yeah.
that what he recalls is that the Schutz Quarry was being utilized by the county on an intermittent basis for maintenance projects within the area.
Oh.
And that during his tenure of 26 years, he remembers it always being an open, active source and it was used multiple times,
It was his recollection.
his recollection.
I'm looking at the 1990 aerial photographs in 1991. You guys want to look at that? And I don't see any change in the footprint.
And
If he's taking rock out of 1990, shouldn't 1991 show some?
When again, as you can see, we took 3 small shots in 2008. The quarry has not expanded in over 10 years because rock is slowly being hauled out, right? So there's rock piled on site, vegetation grows over it as you haul things out. It may take decades in a quarry like the Schutz Quarry before that rock is all gone, and then you have to do another sequential blast. So for instance, in 2008, we did 3 small shots. We then have a large amount of rock in that site then, and in the last, now going on 12 years, there's been no additional blasting, and there's still a ton of rock stockpiled there because it's slowly being hauled out and used as it's sold. It's highly determinative on market conditions for a small quarry like the Schutz Quarry.
All right.
That's
Any more
why
questions?
that's why
Any more
using it
questions
as
here?
looking at one of the larger quarries to the south, using that as a basis for the Schutz Quarry is kind of inaccurate. If the Winnebago Quarry to the south was being used at a bigger scale, it may have been one of their main quarries. The Schutz Quarry's always been a small local rock quarry.
Okay. Do we have any comments, additional information that from, what?
One more question. Who took this photograph?
I took the photographs of the Schutz Quarry and sent to the expert.
Any members of the public wish to make a comment? If you do, we'd appreciate you. There's a log there. Come up and sign your name on the log. Yeah.
Do I have to give my address? You know who I am.
most of us. Well,
Yep.
Can you hear me now?
can hear you.
Thank you. Mr. Krukow has an interesting argument that you cannot rely upon aerial photos, and yet he uses aerial photos. I find that to be a contradiction. I moved here in 1992, August 1. I would take my dogs, 2 of them, down to Camp Winnebago to run them around. I drive by the Schutz and the Lang, and I kept mentioning to my wife, gee, those look kind of old. I didn't see any activity except the growth of vegetation. And they weren't growing on top of stockpiles either. Should I make out an affidavit? It's a little late for that. But I got eyes, I got memory. Both dogs are dead.
Worked them too hard.
Mr. Krugo talks about a time frame from 1968 to 2005. That seems to be the crucial time frame to determine discontinuous use. And discontinuous use is referring to longer than 12 months of inactivity, correct? Well, all you need to do is ask other people that have been going up and down Winnebago County 5 during those years, and I'm sure you'll get several people that will say, I've lived here a long time, and there were many years where nothing was happening there and there was no stockpile. He talks about intermittent use. Somebody up here on the dais talked about, well, what about the skyline or the Winnebago Quarry? It looks like it's, over the time of the aerial photos through time, that it looks like it's been reduced. There's less white being shown. You can't reduce the size of a quarry, correct? That would be filling in or reclaiming. There's been no reclamation at Skyline. There's been no reclamation at Lane. There's been no reclamation at the Schutz. So there's always been expansion, always, or none. You can expand downward, and aerial photos won't be able to determine depth with what we have. I'm sure there's more sophisticated photography now, but we can't use that because it's retroactive. A CUP allows you to be intermittent indefinitely. Skyline Winnebago has a CUP, and there may be 5 years where they don't pull anything out, and the trees start growing, the shrubbery starts growing. But of course, the CUP allows them to be inactive. That's what you pay the big bucks for. Correct? You have license to do nothing when you have a CUP. License to do nothing. You can grow bird nests there all you want to. But if somebody dials up and wants some rock, you're legally allowed to do that because you have a permit that allows you to do that. Thank you.
Thank you. Anybody else have comments, additional information? Hearing none, we'll move to the next. The county representative, got any additional information or reply to any of the questions or points?
I'd like to first start by describing the application process for a CUP. The zoning office cannot refuse an application for something. I do recall making a comment to Mr. Krukow about being busy. That's a comment in jest. That's not a comment that means that you're not allowed to apply. At that point in time, the CUP application was posted as a PDF on the county website, and should somebody bring a completed application in and pay their fee, I would be obligated to forward the application to the Planning Commission. Currently, the CUP application is accessible through the Beacon website, does not require any sort of pre-approval from the county in order for one to be submitted. So any suggestion that a CUP application was refused is unfounded. I will point out that that's completely unrelated to the point that the board should be focused on, which is does the Schutz Quarry meet the non-conforming use criteria? Secondly, before I turn over to Mr. Squires, I'd like to briefly address the findings from the first hearing. During that hearing, Mr. Anderson, you proposed a finding to support overturning my decision that stated that the prior zoning administrator consulted with the highway engineer and county attorney prior to the 2008 decision. That motion failed due to a lack of a second, but made me concerned that I was not effectively communicating what the issue was, or at least I was not effectively communicating it to you specifically. Who the prior zoning administrator consulted with prior to his decision did not and would not make any difference. What would matter would be the information he gathered and how it aligns with the criteria for the non-conforming status. A decision that could be from 2015 that could be relied upon would state what information was gathered, not merely who was consulted with. Indeed, the zoning administrator could have consulted with the engineer, and the engineer could have counseled him to shut the quarry down. We don't know based on the information that's provided in that 15 decision. Because it is not documented, we don't know, and because it is not documented, we shouldn't rely upon it to reach a judgment here today. The more I thought about it, the more it seemed unlikely that the county engineer would meet with the zoning administrator on site and provide information relevant to the non-conforming criteria. So I inquired with him and learned that his involvement had nothing to do with the quarry's non-conforming status, but rather was involved with a complaint about a rock crusher in the right-of-way on County Road 5. With the board's permission, I would submit that email demonstrating that he was not consulting or providing counsel on the non-conforming status of the quarry at that time. Also, I would provide a corrected version of the most current DOT quarry list, which simply has a change in which sites are highlighted. In the one in your packet, the Schutz Quarry and another random quarry is highlighted. In this corrected version, the Schutz and the Logger are highlighted.
Highlighted as.
What is the significance of that?
Just for ease of use and so that the record is complete. Highlighted is in yellow where everything else is highlighted with a highlighter.
Yeah, okay, yeah. Just the fact that it's on the list.
Correct, so you can easily distinguish between
Okay.
the two. I'll turn it over to Mr. Squires.
Approach the board.
It goes with this.
The statutory provision that deals with Board of Adjustments considerations of appeals of administrative determination says that your decision's supposed to be in writing. And this isn't like a variance where you have statutory factors and you probably have a form that you use. There aren't any specific factors for you to apply in considering an appeal of a determination. The standard really is, based on all the evidence, do you believe that the zoning administrator correctly applied the ordinance or not? So there aren't any handy-dandy factors, but you do have to adopt written reasons for your decision. So I have prepared, without the benefit of having seen materials from the Krukows, which were not given to you in time, but just provided tonight, I have prepared findings that I'd like to walk through very briefly and address some of the issues raised by the Krukos. So on page 2, under paragraph number 4, those are really the highlights, and I just want to hit, I think, some of the important points that, as Aaron talked about, he found supportive of his determination. And I'd like to focus principally on the aerial photos and the evidence of the photos, and the photo in particular taken by MnDOT. Now that was dated 1991, and that had a statement on it, as you can see from the evidence submitted to you, abandoned 25 years ago. That statement was not rebutted in any of the information that the Krukos provided to you. Now, they introduced a relatively self-serving email from MnDOT that they put in the answers that MnDOT supposedly sent to them on that, and suggest to you that MnDOT, that this photo shouldn't be given any credibility by the board, because MnDOT's intent and purpose of taking photos is not to document the loss of non-conforming rights. Of course that's true. That's not MnDOT's purpose. That's your function. That's a county function. MnDOT doesn't care about that. Their purpose for taking the photo was some other reason, MnDOT's interest and purpose. But that doesn't mean that the evidence doesn't exist. It is what it is. So the fact that he said that doesn't mean you can't use that information as probative evidence to support your determination tonight. The Krukos also didn't rebut the orientation indication on that photo, that it was taken with a northwest orientation, and that the other quarry that they allude it was really the Lager quarry can't be taken in a photograph with that orientation. That wasn't addressed by them at all. They attempt to cast confusion by referencing the fact that Lager and Schutz quarries were at one time shared a code, but as you can see from the materials they provided, that shared code is 28-33 and -33A. That's not what the photo shows. It uses the code 280833, which on the MnDOT quarry log is unique to the Schutz quarry, and the Lager quarry has a distinct and separate numbers. Those are what Aaron referenced when he talked about those two highlighted ones correctly. You can see from that MnDOT log that the Lager quarry has a numbers separate and distinct, and the only indication in MnDOT's records of what quarry is 28003 is 28033 rather, is the Schutz quarry, not the Lager quarry. Now they also attempted to suggest that this couldn't have been the Schutz quarry because it references Hector. The photo says Hector Construction. In that same document you see that on the line of the Schutz quarry it indicates Hector Construction as well. So another attempt to mislead you to suggest, oh, this had to be the Lager quarry because Hector wasn't involved and the photo said Hector. Well, the MnDOT log says Hector as well, consistent with the photo. The Courtney McGinn affidavit, interesting, again, not provided to the county ever in the first proceeding, not provided to staff, not seen before tonight. But what does Courtney McGinn do? She compares a 91 photo to a present day photo after 10 years of activity at the site, where Mr. Krukow just conceded included mining and blasting. Of course the rock face and the ledge is going to look differently. They've blasted it, changed it, removed materials. It's pretty easy to say it looks different today and my measurements today show that it's different than it was in 91. Of course it is, given that activity that's occurred over the last 10 years, which is not disputed. So I believe that you have to consider that in considering whether there's any credibility to McGinn's affidavit saying, wow, this is a different rock face than existed in 91. Well, that's evident that it would be. So that's really a key document, and that is indicated in the findings as a significant document. And then items 4, 5, and 6 under paragraph 4 really go to the lack of evidence. So you have been presented with information by staff on what they have gleaned from all this historical documentation and analysis. And that is Mr. Locker's opinion that all these things that he's talked about demonstrate no use of the site for mining during a long period of time. So in light of that, what have the Krukows offered in term to rebut the assertion based on all the information that staff has provided to you? In the late 60s, in the 70s, in the 80s, none of the information that was submitted today by the Krukows address that period of time. That's 20+ years of time that is unaccounted for, that Mr. Locker's analysis demonstrates a lack of use of that mine. They've introduced the miner's affidavit that talks about what he thought was going on in the 2000s. They've introduced the Krukow affidavit, again focused on the 2000s. As has been pointed out tonight, that's not really relevant. We're talking about a much broader window that goes back much further than that. And again, statute only requires you, there's a dispute about whether it's 6 months or a year, let's say a year. Statute only says that you have to find a year of discontinuance or non-use to determine non-conforming rights have been lost. The Malling affidavit, the other thing that even addresses issues, Mr. Malling says, well, we used the mine intermittently during my tenure as a county employee. What does that mean? That doesn't tie it to any particular period of time. But at worst, if he means intermittently, if he means during his entire tenure, all the time with the county, based on his years that he served in the county, as Mr. Krukow indicated, that goes back to 1990. It doesn't address 68, the late 60s, the 70s, the 80s. That's the information that's been devoid in this process, and you heard nothing tonight from the Krukows that indicate and rebut the conclusion that Mr. Locker reached, that there was no use of that mine during that long period of time. And again, 1 year is sufficient. Here, there's 20+ years where there's zero evidence offered by the Krukows or on their behalf that indicate that there was anything going on during that period of time. That, I think, is what's significant. And I think you wanted a much shorter rebuttal, so
No,
I will
that's
leave
fine.
it at that.
Do any of the board members have any questions, clarifications for these guys?
So, Attorney Squires, once there's 1 year of inactivity, you don't get it back by starting up activity.
You don't.
It's gone, right? It's gone.
Non-conforming rights, once they're lost, they're lost.
For 1 year.
Correct, yep, and that's statute. And we have a dispute about whether the ordinance is shorter, but for the sake of tonight, it really doesn't matter. That's irrelevant. The opportunity under the county ordinance for the property owner is to apply for a conditional use permit and obtain that. Mr. Locker addressed that process.
Any more questions?
Thank you.
All right, Krukow, you have comments, additional information?
Just to cover a few things. The source number on the 1991 MnDOT photo is actually 428033. So if we're really being technical about the number, it doesn't match the source number of the Schutz quarry either. Because what's the 4 from, right? The actual number is 428033. And again, the only point we were trying to make is that MnDOT can't verify this information. The fact that they list Hector Construction when we know Hector never operated the Schutz quarry just tells you why MnDOT's information was never verified and shouldn't be relied on.
We would ideally have all of our public records accurate and complete. We know that never happens. It's, you know.
Exactly. But if you're going to
They're run by people.
If you're going to take away a property right, though, you need proof of a 12-month period of discontinuance. And the point is, MnDOT's saying that they can't verify their information. They don't know if it was accurate or not, and it shouldn't be relied on. Now, Mr. Scanlon made a decision in 2008 based on what he had. He states what he did in his affidavit. He looked at the aerial photographs, and he determined that aerial photographs sometimes are not good indicators of whether or not a source is being used or not. The point of that is, you know, the county doesn't have anything from the 60s or records. No one keeps records that long. Nothing from the 70s. They have some aerial photographs from the 80s and 90s. But the point with Mr. Scanlon stating is that aerial photographs oftentimes will not show slow levels of use. And with quarries that aren't expanding every single year like the Schutz quarry, like I said, it will be 20 years before another, you know, between shots, where there's no quarry expansion happening. Rock is still being hauled out, but there's no expansion because the quarry is a very small rock quarry, less than an acre in size. It's not growing rapidly. And in between shots, vegetation is growing. As you saw in the current photo, there's vegetation growth that would obscure any aerial photograph, which is why our point is that aerial photographs are not good, reliable sources on a small quarry like the Schutz quarry, where it's not going to pick up small levels of activity. So I just want to conclude that in 2008, before we entered into the lease, the lawyers recommended that we get confirmation that the Schutz quarry was a legal non-conforming mine. We asked the county for that. They investigated it. It was determined to be open and usable under its registered status. That was a determination by Mr. Scanlon at the time. We relied on that decision. We've entered into contracts based on that. When it was a complaint filed again in 2015, Mr. Scanlon looked at the aerial photographs and came to a different conclusion than Mr. Locker does because of his concerns with relying on aerial photographs for a small quarry like the Schutz quarry. Again, we relied on the 2015 decision. We've been operating it. The county's been collecting taxes on it. The county's utilized the site. And now we're told it's shut down because Mr. Locker says that the 2015 and 2008 decision don't mean anything. How can anyone rely on decisions when it could just be reversed tomorrow? And the problem is if there's no weight given to the prior decisions, what happens when a new zoning administrator comes in and says that he finds Mr. Locker was wrong, and now reverses it, and we're back here again? This issue was decided in 2015 and 2008. We ask that you guys uphold Scanlon's decisions because he found that the aerial photographs were problematic. Nobody has records from the 60s. We do have an aerial photograph of 1968 that shows an open quarry. It was registered in 1972, which is an overt act by Kate Schutz that it was an open source. And regarding the quarry wall of the expert opinion, additional blasting didn't happen on that side of the quarry. It was further back. And she addresses the difference of that quarry wall, specifically that's photoed in the 1990. No additional blasting happened on that side of the quarry.
I guess in fairness, the issue I have is that piece where you said the only evidence you had that there was activity in that, at 67, 68, for 5 years, say, after that, was a guy that lived there, and he said, he kind of said, well, we went there and got gravel out of there sometimes, but that's ambiguous, that's unclear, and I don't see any evidence that anything come out of there from 68 to, say, 70. We keep talking about this. The public comment is closed, I'm sorry. We keep talking about this in the 2008 and 9, we go over that, but that's the piece that's the clinker, the one that's tough for me to get past.
With regard to that issue, there's no evidence either way. Mr. Locker, the zoning administration, did not present any evidence from that time period. They didn't present any photographs from that. If there's no evidence, it's their burden of proof. That means that there's not sufficient evidence to show a period of non-conformity.
I think there's a number of photographs from the 70s and 80s.
I think the period that Mr. Hafner specifically referenced that I wrote down was 1968 to 1970.
Well, the zoning ordinance wasn't enacted until
72.
72.
No, it's 19-
68.
Oh, 60.
1967.
Is
67.
68 to
68,
90.
okay, gotcha.
And then one more point with regard to the 1991 MnDOT photograph. Mr. Squires pointed out that it states abandoned 25 years ago. 25 years prior to 1991 would have been 1966. The photographs from 1968, everyone agrees that shows an open active quarry. There's photographs from 1977 where you can see the quarry.
Well-
Mr. Locker showed a photograph from 79 that shows the quarry. So 25 years,
Those same photographs you can't rely on.
if we're gonna rely on this photograph.
Right. I know, but I mean,
And again, that's
you
the problem.
can't
with
cherry.
That's
relying
the
on
problem
aerial
with it.
photographs. And nobody has records back in the 70s, 80s. That's part of the problem.
Well, but we have statements of owners that says, no, it's not active. Now,
I don't-
maybe they say, well, I didn't understand and blah, blah, blah. But, I mean, we can't second guess what they were doing. This is what they.
I'm sorry, you said there were statements of owners that said it wasn't being used?
Well, who was the Gary, he said, is it active?
Gary
Well,
Miners?
Yeah, and he said no. I mean,
But he explained in his affidavit what he meant when he answered no. He didn't mean it wasn't active the way Mr. Locker is currently interpreting it.
that's what he would, I mean,
Mr.
That
Mr.
is true, I'm Gary Miners, and he is correct on that.
This is an opportunity for rebuttal rather than.
Right, exactly, I
Yeah,
agree.
yeah,
Let's,
I'm sorry.
let's
We-
take it to the next.
yeah. Do you have, we should, do you have anything more?
Again, the only evidence that is there is some aerial photographs that are snapshots in time. They don't amount to what's going on the other periods of time of the year. Vegetation can be there showing growth, but it doesn't mean that it's not being active as you saw in the current photographs. It's not a good indicator of use for a very small quarry like the Schutz quarry.
All right,
So,
thank you. Close the public hearing. Well, it's time for us to make a decision, figure out what are the, for me, the main issue is that piece from 68 to 70 or what is the time period there? When did that sell?
1991 photos.
Yeah, when did that sell to Minor? What year was that?
'05.
'05? And there was,
Can you make a motion to close?
yeah, oh yeah, I guess I just said we did.
I'll make motion close.
Make it, I'm sorry.
Second.
2005 says on the second page.
We have a motion and seconded to close the public hearing part. All in favor say aye.
Aye.
Opposed, same sign. Motion carries. All right. What are the main parts?
Well, I guess for me, looking at the aerial photographs, knowing that the Winnebago quarry was active during much of those years and appeared to be shrinking also. I
Okay.
have very low reliance on the aerial photos. And I think the burden of proof has to be that it was not active. Not that it should be the county showing that the activity wasn't there.
Mhm.
And that isn't, to me, not there, obvious.
That's not a,
I can't go by the aerial photos.
okay, all right.
I, on the other hand, have confidence that the aerial photo that from 1991 that was provided by MnDOT, which shows a great deal of vegetation, trees that are obviously 10 and 15 years old. I'm comfortable with that. I'm also looking at the fact that it wasn't taxed as a quarry. When I look at these 1991 photos that were provided by and the affidavit that was provided by the consultant, I'm not comfortable with the fact that the photos, not only has there been a lot of changes to the quarry because it was being used, but I'm not comfortable with the fact that the photos are of a completely different angle in the quarry. And so I don't have confidence that that her testimony about it being a different quarry is accurate. I rely on Gary Miner's first response to the question. I think it's easy to change your mind when things don't go right, and so I'm going to rely on his first response. And as far as the Scanlon decision is concerned, I have very little confidence in Bob Scanlon's decisions. I think that he was flying by the seat of his pants a little bit and simply relying on that 72 list. And so I would not rely my decision on what Bob Scanlon had done before. And I don't know that, based on what I understand, this is a legal non-conforming use and is open to review at any time. It's not like a permit, and so what we're doing is not eliminating a permitted use. We're reviewing and considering a non-conforming use and whether in fact it does still conform. So the idea that we need to rely on Scanlon's previous decisions doesn't make sense to me as well. So those are my issues.
Well, I agree with Ken Bisker there. I was kind of stole my thunder. I'm looking at that photo of the 1991 of the quarry. You got birch trees that are over 30 feet high all over the bottom of the quarry. I mean, birch trees, I know they take longer than a year to grow that tall. So to me, that proves that quarry was inactive for at least a year. And I know it's a lot more than that.
Yeah.
And when that's enough to deny the non-conforming. I also agree about Mr. Miner's filling out that form. He wrote what he wrote the first time. That's what Aaron Lochner had to go by. We're here to determine if Aaron made the right decision in doing this. And I think that anybody would make that decision just reading that form. You don't have to be a mind reader. Aerial, I agree with aerial photos. You can see there's trees in the photos. It's not just a blob of green. A lot of them show trees. So I guess I agree with Ken Bisker.
Ed?
Well, I'm one who's still, I don't trust the aerial photos because what I know is an active mine down there was also showing the shrinkage and stuff in those periods of time. Depending on what year you looked at it, it got smaller or bigger. It all depended on which. And I know that was an active mine.
That was active, and it shouldn't have been shrinking. So,
Right.
What even as I look at them, I think, well, depends on what early summer, midsummer, fall.
So that's why I have a very low faith in using the aerial photos.
How about any of the other issues? We got to put these in the form of
I think that's what we're doing.
Huh?
I think that's what we're doing.
Yeah.
My own, my preference, I don't know if it's the right way to go or not, would be to grant continuing use until the time that a conditional use permit could be applied for and received. But then that would be roughly a year or something like that. I don't know how long it takes. But only until they can get a conditional use permit.
I agree with that, but talking to our legal counsel, that's not our job, is to find that solution. We're here to,
I
We
don't,
don't,
And I-
we
and I-
don't give out solutions, we're trying to.
I
we're
agree
trying to-
with you. That's why I brought it up. He said, but that's not our
I
job.
think it'd be.
I don't think we can predicate our decision based on whether in fact they apply or whether it's available or anything. What we're looking at is whether in fact this particular mine meets the criteria and the test for a non-conforming use. And I don't think a conditional use permit should be in our discussion.
I agree, and I would have the same, okay.
Be a nice solution if it was available, but it's not. I don't think it is.
How do we put them in the form of a finding?
You have your discussion, now you turn back around and you make a motion.
You do have, I presented to you proposed findings, you're free to accept them, reject them, modify them, but again, the statute requires your decision to be in writing, so it seemed to me that, proposed findings would be an easy vehicle for you to work from, to adopt.
I appreciate that, but I think in fairness to both sides, we have to develop our own findings, but I appreciate it. One of the findings is,
Make a motion and then do a roll call.
all right. Go ahead.
Well, I'm just looking, I'm trying to find, because I got so much paper in front of me. What if we, does this sound reasonable that we use the petitioner's objections and respond to each one of those individually? I don't have that in front of me, but there were like 5 different things that were mentioned in the petition that were at issue, and if I had it
Yeah, I
in front of
remember
me.
what you're talking about now, but
I don't have it in front of me, and I probably won't find it for several days. Anybody know what I'm talking about? It's just a thought. If it makes sense, we could do that, otherwise,
okay, appeal of the decision, is that what you're looking for?
yes. Grounds for the appeal.
It's about the third or
Would,
fourth page.
if
of
we
that
use
page.
these, the decision is arbitrary, the decision is not reasonably supported, the decision is
This one?
revoked to
Yeah,
property
yeah,
interest,
I think, third or fourth
and
page.
responded to each one of those. Does that
No.
sound like a reasonable way to
Exhibit 1, second.
to handle this?
Yeah, you should answer more than yes or no.
Yeah,
You should
no, we-
offer
yeah,
your-
no, we would
your
support those.
Reasons why, and
Right.
cite the evidence that you've been provided either way.
Yes.
Whatever decision you reach.
All right, let's go with that, huh?
Number 1, I have a hard dealing.
Well, let's go to the next one then.
Well, we can
Not
do,
reasonable.
I can respond to
Can-
number
can-
1.
Well, we need to form it into
Yeah.
a finding.
The suggestion that that we have been or will be arbitrary, capricious, and unreasonable, I think is refuted by the fact that we've had a public hearing, we've had 2 hearings, you've had
Right.
opportunity to present your case, you weren't cut off. We've all listened and tried to use our best judgment to make a decision, and I don't see that as evidence of arbitrary and capricious.
Make a motion that we have,
We reject that. That
okay.
essentially, that
I think
part
what
of
they're
it.
referring to is that Aaron is the one that made that.
Page 1.
Page 135.
We're looking at appeal of the decision of the zoning administrator dated February 2nd. It's from the
135.
Kukos.
135 of what Aaron sent us. It's Exhibit 1.
What I would recommend maybe to make this easier is you discuss the decision and the bases for your decision tonight without trying to adopt findings yourself, but then direct zoning staff to come back with draft findings consistent with your discussion and reasons tonight.
All right.
To be adopted at your next meeting.
Works for me.
You okay with that?
Which gives you more
Yep.
flexibility, but still to verbalize and come to your conclusions based on the evidence and then direct staff to prepare
All right.
those findings.
Let's do that.
And to some extent, you've done that already in discussing the evidence.
Yeah.
Yeah.
And Ken has already,
Can we just add that you guys actually, under the statute, have a lot of authority and to determine how you want this to come out. I know it was talked about, giving us time to go through a CDP process. You do have that authority. You guys can determine if you want to fully affirm that decision, reverse it, partially modify it. You guys have a lot of authority to come to a decision that you think is the best one in this case.
I thought the hearing was closed.
I just,
Thank you.
Responding
I-
to
I-
what
responding to
Mr.
that,
Squires
so.
said.
I agree.
We're not presenting evidence.
No, I
No, you
know.
weren't.
I don't think we have the ability to respond to anything but the
in the, all I'll
illegal.
say is, in the ordinance, in the relevant statute for the Board of Adjustment, it says you have all the authorities of the zoning administrator to make fully affirm, fully reverse, or modify the decision however you feel is necessary. And so I ask you guys to please take that into account for
Makes
us.
sense.
Okay.
Thank you.
This
Yep.
is a serious
That's
decision.
right, I remember
That's
really
true.
reading that.
ask that you take that into account.
how do you feel about
To be
that?
clear, though, you don't have the authority when it talks about modifying the decision, you don't have the authority to grant a use to continue if you conclude they have lost their non-conforming rights.
That's me.
Then their option or remedy is to apply for conditional use permit in this case.
Right.
All
So
right.
you don't, it doesn't mean you have the ability to do anything you want, even if it's.
We're gonna go through these, and, there's 7 points.
Well, we don't have to do that.
No,
Huh?
we
We
don't
can
really
just,
have
we're
to
just
do
gonna
that.
discuss our thoughts and then,
You answered the first one already.
I'll vote on your ultimate decision and instruct my office to prepare findings for you in support of your decision, which you can adopt in the assembly.
okay. So I've said essentially what I think about this, and maybe are there any other issues that we should talk about?
Well, all right. For me, the issue is, and it remains, that first 5, 8, 10 years. And the best that they could have is, mowing, lived there, and he went there, and, yeah, we went there a few times, we went there a bunch of times. I mean, that's so ambiguous that it's, you can't depend on that. And I come in here looking for an answer to that, and I didn't get that. And the question is that, did our zoning administrator do his job, and was that a reasonable decision that he made? And I think, yes, it was.
And I'm one who, I think the previous administrator's decision was reasonable.
Well,
Those are both, Mr. Scanlon made an opinion, and I thought his response was reasonable.
well,
I stated my opinion of Mr. Scanlon's decision, so
Yeah.
we disagree.
yeah, there was, and.
But we have two different opinions from the zoning administration, and they're conflicting.
Well, and even if that was true, I was gonna say township, the county still has the right, you might say obligation, to bring them into conformity as well. there are things that need to be resolved, you know. Normally quarries have large amounts of diesel fuel. They have to have a procedure for that and, you know, setbacks and, I mean, that, and I'm maybe way overstepping here, but because you have that grandfathered in, for lack of a better term, you still, the county still has a right, and I would say an obligation, to at some point bring this into conformity.
Seems to me the issue here is, does it meet the 3 criteria? Was it there in 1972? This is all we have to decide. Was it there in 1972? It was. Did it expand? It didn't. Was it in continuous use? That's the other criteria. It's the only one it doesn't meet. And that's the only decision that we have to make here.
That's really hard to determine.
Well, it doesn't have anything to do with a cup or anything else like
Yeah.
that. It just, was it in continuous use
And
during that period of time? And that's the decision that we have
And
to make as a
basically,
commission.
I haven't seen evidence one way or the other.
And, I mean, our zoning administrator did reasonable research, and to the best of the knowledge he had, he made the right decision. And I don't see any, I prefer.
Again,
Yeah.
we've got 2 zoning administrators who came to different conclusions with basically the same information.
Well,
I would,
I know both of them.
I would,
This one we have is more accurate.
I would disagree that they both had the same information. The decisions that Bob Scanlon made seemed not to have much documentation at all, whereas the decision that Aaron made had reams
Yep.
of
Aaron is very
documentation.
thorough.
So,
From my side.
that's why I have much, but irregardless, we, as a board and as a county, don't have to continue with a previous decision. These are legal non-conforming uses that are subject to review at any time. It's not like we gave them a permit to operate forever. That's not what happened. We have an obligation to review and make sure that these properties conform to those requirements. And so Bob Scanlon's decision, even though it creates hardship, isn't something we have to rely on, let's put it that way.
Mr. Chair, what I would recommend you consider as a board now is one of 2 motions. One, a motion to affirm the decision with a direction to staff to bring back findings consistent with that at your December meeting, or a motion to reverse staff's decision with a direction to staff to bring back findings to support reversal. And then let staff do the work consistent with your discussion, and then you can look at those drafts and whichever way you go and modify them as you wish.
Yeah, that's part of what one of the points here. The next step is to entertain a motion to accept or reject findings with a roll call vote. I guess there's no sense in making a motion of that.
Yeah, mine's a little different. My suggestion is just to not vote yes or no, but it's to direct staff to bring back findings consistent with either
After we,
affirmance
well,
or denial.
okay, then the next step is, I'd entertain, at this point, entertain a motion to accept or reject the Cruco Company's requested appeal to overturn the decision made by the zoning administrator in this matter.
And I would recommend modifying that, to say that the motion should be either to direct staff to bring back findings consistent with affirmation to be adopted or considered at the next meeting, or to direct staff to bring back findings overturning its decision.
Okay,
One
well,
of those 2
does that need to be together, because that was my next motion?
No, I think one of those 2 motions, I think it's a bit different than your sheet probably indicates. I think given where you're at right now, a motion to just simply direct staff to bring back findings consistent with a decision is a better motion, because that gives
Yes.
staff an opportunity to give you something more tangible to look at.
I was gonna get the motion to accept or reject, and then a motion to direct the zoning administrator to bring back findings.
would skip that second to last one again, not making the substantive decision which you would make at your next meeting once you have the findings.
Oh, really?
Those would be your written reasons, so you just,
We don't make a final decision here?
no, you're directing staff to bring back findings consistent with
And then
one
we,
of those.
then we take a motion on the findings at that
At the
time,
next meeting.
And then you act on those
Yeah.
findings at your next meeting.
if they're consistent.
Well, I'm still confused. You're asking
How
us,
can staff draft findings based upon what you decide if they don't know?
yeah,
What
we
we
have
just-
to decide.
Because
What
We have to
you're
make a
basing-
decision.
What you're basing your decision on.
You've already
Yeah.
had that discussion about what the evidence that's most important to you is, so staff will attempt, this is done all the time. Staff will attempt to synthesize the information, that was provided and that you've discussed as being important to you in the form of findings. And then at your next meeting, you look at them and you may add, you may subtract, you may refine, but it's something tangible for you.
And then we make the decision? Is that what you're saying? And then we make the decision to reject or accept?
You can
We need a
alternatively, if you
motion.
wish, you can make the decision now and direct staff to bring back findings as well. That's your prerogative, if that's what you wish.
I would move that we reject the petitioners
Appeal.
and ask staff to bring back findings pursuant to that motion. Does that make sense?
And consistent with your discussion.
And consistent with our discussion, fine. So I'm moving to reject the
Do I
petition.
have a second?
I'll second.
We have a motion to,
Can we repeat it?
wanna read it? Well, let's go with what I had.
Say it one more time, Ken.
Wait a minute.
I move we reject the petition and instruct staff to bring back findings at our next meeting that support the decision.
And are consistent with your
And-
discussion.
And are consistent, that's fine, are consistent with our decision.
I've got one here.
Pardon me?
Decision you said at the end.
That's right, with our decision.
Motion to reject Cruco Company's requested appeal.
It should be
You just
with
said
both.
That's the
Decision.
motion. You don't have the ability to change
I
this
didn't
motion.
hear.
Yeah, it was decision. You got it? I hope so, because I can't repeat it.
I still second.
Can you read it?
Reject the petition and instruct staff to bring back findings at the next meeting.
Consistent with
uh,
that decision.
Right, right.
Yeah, all right.
So,
Okay, we
read
have
it one
a
more, can you read it one more time?
motion to,
Reject petition and instruct staff to bring back findings at the next meeting consistent with the decision.
There you go.
okay, we have that motion. Do we still have a second? Dana?
Yeah.
Ken? We have a motion on the floor without a second.
Oh, we got it.
No, we got it.
We got
Dana
it.
I did
seconded.
second.
Dana.
Huh?
Dana
I
seconded.
Oh, you did
I
already,
was just
okay.
giving them that.
All right, all right. Is there any more discussion? Hearing none, all in favor say aye.
Aye.
Aye. All opposed, same
Aye.
sign.
Aye.
Motion carries. I'll entertain a motion to, a motion to adjourn.
So move.
I'll second that one.
Ken and Ken.